Hello, hello. Testing, testing.
Mr. Sherman, this is Ben with the Maryland Public Service Commission. Can you just confirm your microphone is
Yes,
working?
hi.
Awesome, we hear you. Thank you.
Commission's administrative meeting for January 17th, 2024. Before we approve the minutes, as some of you may know, our legislative director, Lisa Smith, left the commission to go into private practice, and we have brought on an individual to take her place and be our new legislative director. So I wanted to introduce Christina Ochoa, who comes to us. She was with the Attorney General's office, handling the Maryland judiciary, and she's a graduate of the University of South Carolina, and she received her law degree from the University of Baltimore, which attests is a fine law school. And so we want to welcome Christina to the commission, and she'll be representing us in Annapolis and be up to her eyeballs in that pretty soon.
Yes, thank you so much. I'm thrilled to join the team. It's nice to see all of you. Hopefully get to know your names as time progresses, and great to be here, and I'll be down the hall if you need me. So.
Okay, thank you. Right. Welcome aboard.
Thank you.
So with that, we need to approve the minutes from the administrative meeting of January 10th, 2024. Commissioner Sushman.
Aye.
Commissioner Barbet.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Secretary.
Good morning, Mr. Chair. There are 7 items on today's consent agenda. The first is from Potomac Electric Power Company. It's revised tariff pages that update to its standard offer service rider, updated to reflect SOS rates for Type 2 customers and Type 1 and residential rates. Item 2 is Delmarva Power and Light Company, its revised tariff pages, also for its standard offer service rider to reflect SOS rates for Type 2 customers and Type 1 and residential rates. Item 3 is from Affiliated Power Purchasers International LLC. Its request to cancel its license and notice of acquisition by Environ Energy LLC. Item number 4 is Paytel Communications Inc. Its notice of transfer of ownership of Paytel Communications Inc. to Paytel Communications ESOP Trust. Item number 5 is Jerome Allen Cohen. Its application for a license to supply electricity or electric broker services in Maryland. Item number 6 is Sustainable Energy Services, Inc. Its application for a license to supply gas or gas broker services in Maryland. And the last item, number 7, is Travelers Casualty and Surety Company of America. Its bond cancellation for Triangle Energy, LLC.
Okay, so regarding items 1 and 2, I move we accept the tariff provisions for filing with an effective date of February 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbet.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Regarding item 3, I move that we approve the cancellation request and note the acquisition of the company. Commissioner Sushman.
Aye.
Commissioner Barbet.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Item number 4, I move that we note the filing by Paytel Communications Inc. Commissioner Sushman.
Aye.
Commissioner Barbet.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Regarding item 5, I move that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. That we further direct the company to file notice with the commission within 30 days of any changes to the information and the application, and finally grant the company a waiver of COMAR 20.51.02.02B5, requiring businesses to provide a certificate of good standing in the state of formation. Commissioner Sushman.
Aye.
Commissioner Barbet.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Regarding item 6, I move that we grant the company a license to operate as a natural gas supplier in Maryland, limited to broker services and aggregator services for the customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the commission within 30 days of any changes in the information in the application. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. And then finally, regarding item 7, I move that we cancel Triangle Energy LLC's gas and electric supplier licenses. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Moving on to the administrative agenda, the first item, number 8, is from the Potomac Edison Company, a request for a CPCN waiver relating to Carroll Substation 230 kV structure replacement.
Good morning, Mr. Chair, Commissioners, Chris Fallow on behalf of staff. On November 30th, 2023, Potomac Edison filed a request with the Commission for a waiver for a CPCN requirement as set forth in the PUA Section 7-207B4I. The request is needed to replace one substation structure along the existing Carroll Mount Airy 230 kV line at the Carroll Substation in Carroll County, Maryland. PUA Section 7-207 requires electric company to obtain a CPCN prior to commencing construction of an overhead transmission line that is designed to carry a voltage in excess of 69 kV. It further states that the Commission shall waive the CPCN requirement should it find that the construction does not require the company to obtain new property or rights of way through eminent domain, or require larger or higher structures to accommodate increased voltage or larger conductors. The proposed project allows Potomac Edison to replace and upgrade the existing protection system components at the substation to improve reliability. The company plans to install a replacement structure that will be approximately 67 feet in height. Due to the height increase, the line tension and sag will be adjusted to align with the new connection point and meet the required National Electrical Safety Code clearance. The company states that the voltage and conductor will remain unchanged, and all work will be performed within the existing Carroll substation site. Potomac Edison anticipates that the construction will begin on March 4th, 2024. The planned outage has been scheduled to allow the work to be performed, and no customer will be impacted during the planned outage. Staff concludes that the statutory requirements under PUA 7-207B4I for obtaining a waiver of the CPCN requirement is satisfied. Staff recommends that the Commission grant the company's request for a waiver of the CPCN requirement under the PUA 7-207B4I to replace a substation structure to allow the new substation equipment to be mounted and installed in the Carroll substation within the required clearances. Thank you.
So, any questions for staff? Okay. Welcome back.
Good morning, Mr. Chair and Commissioners. Joey Chen on behalf of Potomac Edison. It is good to be back in these hallowed halls. I'm here today with Travis Turner, one of our engineers. We have nothing further to add to staff's presentation. We would like to thank staff for their analysis, and we are available for any questions that the Commission may have.
So, any questions for Potomac Edison?
Yeah, I have to ask Mr. Chen at least one question. Welcome back. I am interested just to find out if the company has taken a look at this project, and if it the other transmission projects that we're currently looking at in Maryland due to the deactivations of Brandon Shore, the state agreement approach projects in New Jersey, and just a load growth from data centers. Does that have any impact on the need or enhanced need for this project?
Thank you for the question, Commissioner. The short answer is no. This project the driver for this project is completely unrelated to the anticipated load growth from all the factors that you just mentioned. This project is really driven by reliability, based on the historical metrics that we have for the substation components, and because of the necessary upgrades to make sure that the substation meets and exceeds the NERC and the company's own misoperation requirements, we have to raise the line. So that's the driver.
Okay, appreciate that. Thank you very much. Thank you, Mr. Chairman.
Any other questions?
Yeah,
Oh,
I got a question.
no. Commissioner O'Donnell, go ahead.
Thank you, Mr. Chairman. Mr. Chen, is this related in any way, directly or tangentially, to the ICE project West?
Thank you for the question, Commissioner. I believe the answer is no as well, but I'm going to invite my colleague, Mr. Turner, to come and
Okay.
just confirm that.
Mr. Chen is correct. It is
Actually,
not related.
if you could just identify yourself for the.
Oh, I'm sorry. My name is Travis Turner. I'm with First Energy. I'm an engineer.
Okay, go ahead.
Yes, Mr. Chen is correct. The answer is no.
Anything else?
Thank you.
Okay. With that, I move that we grant Potomac Edison's request for a waiver of the CPCN requirement under Public Utilities Article 7-207B4I to replace the substation structure and allow additional clearance between the existing conductor and new substation equipment being installed at in the Carroll substation. Commissioner Sushman.
Aye.
Commissioner Barve.
Let's see.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Thank you, Mr. Chair. The next item on today's agenda is from the Potomac Edison Company. It's Electric Distribution Investment Surcharge Report for 2023 and proposed EDIS rates for 2024.
Mr. Chair and Commissioners, Chris Lowe again on behalf of staff. This item is the 5th annual report and the associated tariff revisions filed by Potomac Edison for its Electric Distribution Investment Surcharge, EDIS. Under Public Utilities Article Section 4-202, the electric company tariff is to include its rates and charges, terms and commission conditions, policies, practices, and provided regulated services. In Order Number 89072, Case Number 9490, the Commission approved a surcharge to recover costs of reliability improvements regarding distribution automation projects, reclosers, underground cable replacements. The 2023 work reported in this filing includes installation of 2 distribution automation projects, replacement of 14 reclosers, and 51 miles of underground cable. As discussed in the staff comments, the overall EDIS cost estimates for 2023 have increased 5.4% from the original cost estimated proposed by the company in 2022 EDIS filing. Staff notes that the labor, materials, and engineering cost increase largely contributed to the cost variance for the 2023 EDIS programs. Staff has also reviewed the proposed EDIS revenue requirements and the associated surcharges for different customer classes. With all the proposed changes in 2024 EDIS surcharge, an average residential customer using 1,000 kilowatt-hour a month would have a bill decrease of $0.94 compared to the 2023 EDIS charge. For the proposed surcharge, the Commission in Order Number 90847 in Case Number 9695 determined that the continuation of the EDIS surcharge should not be allowed. The order is intended to end the EDIS programs. Therefore, the rates for 2024 for all rate classes should be removed, and the associated 2023 capital costs should be recovered by the company in a future rate case. The company should be allowed to set up a regulatory asset for their 2023 EDIS investments. After review, staff recommends that the Commission note Potomac Edison's 2023 EDIS report. Staff also recommends that the Commission reject the proposed surcharge and direct the company to file a clean tariff pages with the EDIS surcharge removed. And the following is an addition to staff recommendation. the company should be authorized to establish a regulatory asset for their 2023 EDIS investments. And also note that OPC filed comments on this matter. And thank you, and staff is available for questions.
So, any questions for staff? Okay, so let's go to OPC.
Morning, Mr. Chairman, Commissioners. Ryan Shu on behalf of OPC. As stated in our letter, OPC recommends that the Commission reject PE's proposed 2024 EDIS surcharge on the basis that it conflicts with the intent of the Commission's prior orders, and also the remaining 2023 EDIS project costs are not the sorts of costs that conform with the Commission's justifications for surcharge treatment. As staff noted, OPC's position, we do not oppose the creation of a regulatory account to track the 2023 EDIS cost if the Commission wishes to do so, and I'm available for any questions.
So, any questions of OPC? All right, Mr. Trout.
Good morning, Chair Hoover, Commissioners, Jeffrey Trout, Counsel to Potomac Edison. We can do this the easy way or the hard way. I'm going to start with the easy way. The company in its initial filing noted that instead of continuing the surcharge, deferring all the costs into a regulatory asset and dealing with them in the company's next base rate case was an acceptable approach. Staff has endorsed that approach. The Office of People's Counsel has confirmed that they do not oppose that approach. And so while I am ready to discuss why we respectfully disagree with staff and OPC on the surcharge issue, we don't need to get to that because there is an approach here with which all of the parties agree, which is the reg asset approach. And if the Commission is willing to go down that road, then I think we are done.
Okay, fair enough. Any questions for the company?
Well, Mr. Chairman, I just want to say that I endorse the easy approach. I'm always happy with an easy rather than a hard approach.
We appreciate your accommodation, Mr. Trout. So with that, I move that we note Potomac Edison's...
Sorry, apologies.
Oh, wait.
Sorry, I just wanted to put this on the record. Just to clarify, OPC does not oppose the creation of regulatory asset for tracking purposes, such that it's not accruing
Right.
interest. Right.
Okay. No, we noted that I saw that in your letter. So with that, I move that we note Potomac Edison's 2023 annual EDIS report and reject the proposed surcharge, direct the company to file clean tariff pages with the EDIS surcharge removed, and authorize the company to create a regulatory asset for the 2023 EDIS costs. So with that, Commissioner Schlesman,
Aye.
Commissioner Barve, Commissioner Richard,
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Thank you.
Thank you.
Item number 10 on today's administrative agenda is from United American Marketing Corporation. Its application for license to supply electricity or electric generation services to the public in the state of Maryland.
Good morning, Chair and Commissioners. Charles Herbert on behalf of staff. On October 23rd, 2023, United American Marketing Corp., or UAM, filed an application for a license to supply electricity or electric generation services in Maryland. During staff's review of the instant filing, staff noted the admission by UAM that it had operated in Maryland without a license between September 19th, 2019 and September 3rd, 2022. Staff considers UAM's unauthorized operation period to constitute a set of serious violations of Maryland law. At the same time, staff notes UAM's forthcomingness with staff during the application process, as well as UAM's ceasing of all energy broker operations in Maryland once the company realized it needed a license to operate. Staff believes that the remedial actions taken by UAM represent a good faith effort by the company to return to compliance. Accordingly, staff recommends that the Commission grant the company a license to operate as an electricity supplier in Maryland, limited to electricity broker services to residential, commercial, and industrial customers. Additionally, staff recommends that the Commission issue a civil penalty to the company in the amount of $3,067.34. Finally, staff recommends the Commission direct the company to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license.
So, any questions for staff? Oh, Commissioner Sussman.
Okay, I have a couple of questions about this. First, are you aware of what the requirements are in Illinois in terms of being a broker? Do you need to be licensed?
The answer is no.
Okay. And then, when you are reviewing consideration of a license, do you customarily review training and marketing material?
Yes, Commissioner. We do review it to see that there's, if the company submitted training or marketing material, that there's no deceptive statements such as, we look for phrases like guaranteed savings and things of that nature. So long as we don't see any statements like that, staff is typically fine with the training and marketing materials.
Okay, and were you at all concerned that no training or marketing material was submitted with this application?
So, Commissioner, sometimes the company doesn't submit training and marketing materials. Occasionally, it's the case that, especially in the context of a broker, you're typically not seeing those companies going door to door. And so training materials aren't always applicable in this case. And as far as marketing materials, the company would submit those once before they commence operations. But it's been the case in the past that no training or marketing materials are submitted. But when they are submitted, we review them to make sure there are no deceptive statements.
So in the past, no training or marketing materials are submitted in an application? Is that what you're saying? I'm mostly trying to get a sense of what it is that you review before you recommend that a license be issued. And I'm particularly concerned where you had a broker that had been operating as a broker for 3 or 4 years without being licensed. At that point, I would think you'd want to review whatever marketing materials they would be using in operating in Maryland.
Yeah, Commissioner. It's been the case in the past where the company hasn't. Companies sometimes submit training and marketing materials. Other times they don't. As far as compliance is concerned, we took special note of the fact that at least in Maryland, while the company's been operating, it hasn't received any complaints in the state of Maryland. We did check that information with Consumer Affairs.
Okay, but you didn't ask for marketing materials?
No, we had not asked for marketing materials in this
Okay, and is
case.
that something that you have asked in the past in reviewing an application? Particularly an application where you're a little concerned about the entity. I mean, I understand they didn't have any complaints filed against them, but they also didn't comply with our licensing requirements, and part of compliance is consumer protection. There's a bond, and none of that was in play. And so, have there been instances in the past where you've asked for marketing materials just to make sure that the entity is an entity that understands what's required in Maryland? And clearly, because they didn't understand what was required in terms of a license.
Right. So we sometimes ask for training and marketing materials in cases where the supplier is a full supplier applicant.
Mm-hmm.
sort of going back to my last point, that at least with respect to training materials, it's often the case that these materials are less applicable for brokers than there would be for suppliers. With suppliers, we're more concerned about deceptive statements, especially considering that such companies are directly controlling the rates at which the customer's paying for their commodities, whereas with brokers, they're more focused on educating customers about what's out there.
Yeah, but it's still, I mean, very sort of straightforward materials would be useful, for especially for an entity that didn't understand that it needed to be licensed in the first place. So I actually was wondering why in your buck sheet you treated the information in the penalty portion as confidential.
Right. So I can say with respect to the revenue, staff hadn't realized until after OPC filed that the revenues were in the public version. But as for the weights on the formula, though, which OPC also mentioned in its filing, we would be concerned that some of these weights could be backtracked and used if the formula were to be made completely public. They could be used to reveal the revenues of future companies that file and would like their revenues to remain confidential. So we had concerns with respect to that.
Okay, so in the past, when you've done these penalty calculations, that aspect has always remained confidential?
Right. Typically, and this is the first instance I've seen where a company included revenues in its public version. Typically, companies, when supplying their revenues with respect to Attachment E of the application, keep that proprietary. So in the past, it's been the case that all of the formula and revenue information was kept confidential.
Okay, thank you.
So, any other questions of staff?
Yeah.
Commissioner O'Donnell.
Do we have any other witnesses on this item?
Well, we have, so OPC filed a letter about this, and it looks like we have a representative from the company, so.
Good. I was going to ask if we had a representative from the company. I'm wondering if they could come forward. I have a question or two for the company.
Well, actually, let me hold off and hear it from OPC, and then I'll have the company come up, respond to staff OPC, and then give you a chance to ask them.
Okay.
So, OPC, go ahead.
Good morning. Thank you. Natalie Novak on behalf of the Office of People's Counsel. As stated in the letter that OPC filed, because United American Marketing Corp. Operated in Maryland for almost 3 years without a license, which means that, according to staff's buck sheet, UAM never paid commission assessments, maintained financial security in the form of a bond, or maintained contact information with the commission. And the company wasn't even aware that they needed a license to conduct energy broker services in Maryland. OPC agrees with the civil monetary penalty proposed by staff, as well as staff's request that UAM submit a report with any updated license information within 30 days of any changes. OPC is in supportive of the formula staff used to determine the amount of the monetary penalty. The formula allows for consideration of both aggravating and mitigating factors and would create more consistency between cases where companies operate without a license. In regard to the marketing and training materials, I will point out that paragraph number 23 in the company's application states that the applicant must provide copies of the training materials prior to operation in the state. Provide such material before commencing business in the state. So those materials should be provided by the company. Also, OPC requests that the Commission direct staff to refile its comments for this matter, making the entire filing available to the public without any redactions. As stated in OPC's letter, the Maryland Public Information Act provides that all persons are entitled to have access to information about the affairs of government and the official acts of public officials and employees. Unless an unwarranted invasion of privacy of a person and interest would result, and the title shall be construed in favor of allowing inspection of a public record. Staff already commented that staff wasn't aware that the company provided the revenue information and the account information. So OPC understands that. In regard to the formula that staff used to determine the monetary penalty, OPC believes that transparency is an important part of the retail supplier penalty cases, and hopes and believes that to the extent possible, as much as that formula is made available to the public, and if it is not, that an exception or a privilege under the MPIA is put forward by the company or by staff when things are marked as confidential in the comments. Thank you very much, and I'm available for questions.
So, any questions for OPC? So, just one for me. Just to be specific about this, so OPC approves of the fine amount as proposed by staff, correct?
Correct.
Okay. All right, so I think you're representative of the company, so why don't you come forward, introduce yourself?
Hi, my name is Abdul Elimira, and I represent United American Marketing. I work there in the finance department.
I see. Okay. So, do you have any comments on, before we start asking questions, do you have any comments on either staff's information or OPC's letter?
Not at this moment, no.
Okay. So, questions for the company.
I can't hear
Commissioner
the- I can't hear the
O'Donnell,
company.
go ahead.
I can't hear the company witness.
Oh, so step a little closer to the mic and speak up. So,
So should I reintroduce myself?
yeah, go ahead and do that and,
Okay.
and make the statement that you have no comments on either
Yes.
staff or
So
OPC's.
my name is Abdul Elimira. I work for United American Marketing in the finance department, and I don't have any comments at the moment to what was just talked about and discussed.
Okay, fair enough. Commissioner O'Donnell, go ahead.
Okay, so the company, you're out of compliance for quite a long time, and I note that the staff acknowledges your cooperativeness during their investigation with you and during their due diligence with you, but what have you done long term to make sure you're not back in here with a compliance issue? I haven't heard that yet.
So when we started working in Maryland, it was more of it wasn't the core business operations. We were mainly focused in Illinois, but we were also doing periodically business in Maryland. And since then, our team has grown, and we have more capable staff on our team that are able to guide us to make sure such occurrences don't reoccur in the future. So we have a former lawyer on our team. We have doctors, like PhDs, on our team. So we're hopefully planning on having no issues in the future or any reoccurrences of this nature. So when we started, because the company started in 2013, and then I think a few years later, maybe 4 or 5 years later, maybe they did a little business in Maryland, but it wasn't the main core operations, and it was more something that we would do periodically. And then when we discovered from the suppliers that, in order to continue doing more business in the state of Maryland, you would need to obtain a license. That's when we decided to get a license. And as far as your question is concerned about how do we make sure such things don't happen in the future, we have more, I think, capable people on our team that would know that in order to do a certain endeavor in business, you'll need to have these specific requirements, and we have more people on our team who are able to guide us with more experience in the business industry.
Well, it doesn't give me a great deal of warm, fuzzy feeling, but let me just say this. I don't expect to see this company back before us with a compliance issue, because if you do, we're going to come back to this day and say, you promised us you had it fixed, and you didn't. So get it fixed if it's not, because we're going to be watching.
Yes.
We take compliance very, very seriously, and we take consumer protections as a part of that very seriously. And we expect the companies who are operating in this space to understand what compliance is and meet it. So we'll see, Mr. Chairman. I just wanted to make sure that the company understood that they're not off the hook just because they were nice to the staff in their investigation.
Okay, fair enough. Commissioner Schlesman.
Good morning. So I don't know if you heard my exchange with staff about the review of any materials, marketing or training materials of any kind. They have not reviewed them because you've not submitted them. Do you have training or marketing materials?
I believe we might have some marketing material and training material that we will be able to submit.
Okay, can you explain why those have not been submitted?
I don't know specifically why. I don't know if it was specifically asked, but I believe it was mentioned that we would need to provide it. So we can provide it. It's not an issue, I don't believe, to provide the marketing material.
So, Mr. Chairman, I think I would have a problem with agreeing to provide the company with a license until staff has actually reviewed the materials to make sure that they are in compliance with any consumer-related issues. I actually have a question for staff. So can you explain to me why the formula needs to be confidential?
Yeah, so so the reason why the formula needs to be confidential, and specifically it's the weights we're concerned with, particularly the weight that corresponds to the revenue amount. As I sort of alluded to previously, we don't want a case where, and as I've mentioned, normally the companies that come before the commission with this issue where they were operating without a license and they provide their revenues, they provide those revenues confidentially. And the case that was cited in the Buck sheet, the previous case, is just an example where that company had kept its revenue confidential, and what we don't want is for this formula to be publicly made available, and then for the public to be able to use that to calculate the revenues of companies also who have filed confidentially and wish to keep their revenues confidential.
Okay, so what you're saying is this in this case, since we already know what the revenues are, that's not going to be an issue. But the concern is that in other cases where the revenues were submitted on a confidential basis, you're concerned that you can sort of you can reverse engineer the numbers and be able to determine what the revenues were.
That is correct,
Okay,
Commissioner.
thank you.
Any other questions? Well, actually, I got a few. So let's start with, so what other states do you currently operate in?
So currently we are primarily at this moment, we're mainly in Illinois, as far as I know. Illinois, and then, Illinois.
And you're not required to have a license to operate in Illinois.
We do have license in Illinois for being a broker. So we do have that license in Illinois.
All right, so I guess my question is, I'm trying to understand why you didn't think you need a license here when you started operating here.
As far as I understand it, is we were under the impression that since we had the relationship with the supplier, major suppliers, that since we're selling on their behalf and that we already have an established license in Illinois, that we would be able to do it in Maryland without having a license, which is obviously now we know is not the case, and that that was a false interpretation, an incorrect one. So.
And you mentioned in your statement that you've staffed up some, you now have lawyers on board. Did you have an attorney handling corporate matters for the company when you originally started business here?
No, not at that time, no.
I see. Okay. On this issue regarding the confidentiality, since you've already provided that information, do you have any concern as to whether or not we grant OPC's request to make this public?
Just as far as the revenue is concerned, we would prefer it to be confidential, but that's the main thing. Because we typically don't.
But my understanding is that you did already provide that in this case. So in that sense, isn't the horse already out of the barn?
Provided it to whom?
Well, I guess my understanding is they provided the staff, correct?
Yes, the revenue was filed with the public version of the company's application.
So that means this information is already out there, correct?
That's correct, yes.
So we can't unring that bell, right?
That's my understanding.
All right. And I guess for staff, well, two questions. One, why are you concerned about keeping the fine formula secret? I mean, it seems to me that if there was more information out there about the potential liability for bad actors, won't that act as a deterrent?
To your question, Chair, and I should be specific. What staff is fine with, and in this case, as it's been stated, the company did submit its revenues publicly. We're less concerned about the variables in the formula, so the revenue, the assessments, the number of licenses that would have been required. What we're more concerned with are the weights that are assigned to these variables. So, for instance, the weight that's assigned to the revenue, which is denoted by alpha here. Our concern is that the formula could be accessed by a member of the public and then used to compute revenues of past and future companies, especially if the proportion on the amount, the percentage of revenue was made public in a buck sheet. So what we're concerned with is how this would affect future cases where the applicant intends to keep revenues confidential.
And just for my education, why is the secrecy of revenues so important to retail suppliers?
Yes. Good morning, Commissioners. Harrison Scher on behalf of staff. Typically, a company's revenue is considered confidential. And I mean, that's just been commission precedent.
Well, I understand that that's the precedent, but I guess I'm trying to understand, why is this so important? I mean, it seems to me, how does that impact their operations if you know how much money they're making? Actually, let me.
Kevin Mosier of staff. I would say mostly it's just, I think the suppliers would probably argue that, it's a benefit to their competitors to know. That said, particularly on the electric supplier side, a lot of this data is available at the DOE's Energy Information Administration site. Basically, we've largely been following commission precedent. If the commission decided that they did not want to keep this confidential, I don't know that staff has a terribly compelling reason for saying that that's not a good thing.
Okay. And I guess maybe you're and you can decide amongst yourselves. So I want some explanation. I mean, I read the formula in the buck sheet, but I guess I want some understanding about how you arrive at a fine figure. I mean, this number struck me as being just sort of odd and almost arbitrary, but I understand it was the result of this formula calculation that you went through. So I guess I'm trying to comprehend, my view is a fine should serve as a deterrent, not only to sort of penalize the company for past bad actions, but I would like to see fines act as a deterrent on this industry to make sure that they comply with the rules and regulations.
Certainly. It's a long, complicated background. I mean, essentially we've had, well, particularly with regard to brokers, from the time we had deregulation, I guess around 99 up and through 2011 or 12, we kind of had a policy in place where, because particularly at the time, there was a lot of brokers who didn't understand they needed a license. So our policy was they would be fined $100 or back assessments. At some point, one or more of the commissioners had determined that, it's been long enough, these companies should know, they wanted to bump up the fine. So we bumped up the fine. We had one supplier that was fined, one was fined $500, one would find, I think, $25,000. A few months after that, a similar broker was fined $0. Long story short, we had tried to come up with a formula to try to incorporate commission precedent. If you wanted to go in a different direction, staff is not opposed to that at all.
But if we want to just the fine today, we'd have to sort of come to some determination on our own as to what, because I don't want to pick a number out of the air, obviously, but I guess I'm concerned as to whether or not the fine amount in this situation is adequate.
That's a question we often struggle with, because again, I think we see it a similar way. We don't want the fine to be draconian, but we want to make sure it's sufficient to make sure that this kind of thing doesn't happen again. And that is a tough figure to come up with. I mean, it's sort of like, if I was trying to pick something to make sure somebody wasn't speeding, well, if the fine for speeding is $50,000, no one's ever speeding, but that seems like overkill. $20, I don't know if that does much at all.
Okay. So, actually, let me have the company come back up for a second. So, when you were operating here before, without the license, describe to me what services that you were providing to customers, and how much interaction did you have with residential customers?
So, my understanding is that there was a big portion of it was commercial customers.
Mhm.
So it was like small to medium-sized businesses was the main focus. There might have been some residential, but we also do have, I believe we had at the time, like a website where people could directly enroll with some of the suppliers. So the main focus was commercial, and there might have been also some residential interaction in there as well.
I see. Okay. So I take it People's Council had something else they wanted to add to this?
Thank you. Yeah. Natalie Novak again for Office of People's Counsel. Thank you very much, Chairman. 2 quick points. First, in regard to the equation, it does allow for a range. And I don't want to be the one to reveal the range because I believe that was in the confidential filing. But if the commission So the commission could go on the higher end of the range, which is the percentage of the income, is just one option for adjusting the current penalty amount. And in regard to this formula, OPC sees no reason why this formula couldn't also be applied in cases for retail suppliers as well, not just brokers. In regard to the confidentiality of a company's revenues, if a company wants to redact its revenue information, then the company should be required to show that an exemption or an exception applies. If it's commercially sensitive, then the company would have to show harm to the competitiveness of the company, or possibly that the company would not file for a retail energy license. The company should be required to make a showing that information needs to be kept confidential. And I will, thank you very much.
Mr. Chairman?
So, Commissioner Barvey.
Yeah, let me just say that having spent much of my time in the private sector, I tend to be relatively sympathetic to the idea of certain kinds of confidentiality, but this is a very new domain for me as a new commissioner. So I suppose to the representative of OPC, I presume the stance you take is that the top line revenue numbers are really not something. I guess what I'm hearing you say is top line revenue numbers are not something that should be considered confidential by this commission. Am I correct in getting that from your statement?
A showing, companies who wish to make that information confidential should make a showing under the existing, case or state and federal standards for information being confidential because it's commercially sensitive. Oftentimes, that information is just redacted without such a showing being made. So, at the very least, companies should have to make this showing before that information is.
So, I guess the answer is yes, you do believe that top line revenue numbers ought to be public.
Yes.
Okay.
I believe I will defer to.
Okay. That, not trying to trap you or anything here. I just want to know what your position is. Mr. Chairman, obviously I'm a relatively new commissioner, and it's a new subject matter to me, and so I'm certainly very interested in having us, if we make a decision to change this precedent, I'm very interested in that discussion. I don't personally have a feel right now for where I would stand, but I think it's an important discussion for us to have as commissioners. Thank you.
Commissioner Sussman.
Okay, so let me just sort of understand in terms of process what this would mean. So if in the calculation of the fine, the revenue number is not confidential, would it be confidential when the initial filing was made for a license? Because it seems to me that you sort of have to backtrack so that the initial filing itself with the revenue number, that revenue number would also not be confidential, because you'd have to sort of undo the confidentiality when you're calculating the fine and that fine is in the buck sheet. Unless I'm misunderstanding what the consequence of this would be. Because it sounds like the consequence of this would be, and it's not, I'm all for transparency. So I think this is a good thing. I mean, particularly if the numbers are available. If EIA has the numbers, I mean, it doesn't make any sense that we would allow for confidentiality when the numbers could be gotten someplace else. So, but it seems to me like the consequence of what we would be doing if we're opening it up in terms of a calculation of a fine would mean that the initial filing itself would have numbers that would not be confidential.
And correct me if I'm not understanding your question, Commissioner, but as far as the, I think you alluded to what it would take to make these, staff put in its buck sheet as confidential public. Staff would refile. The commission ordered confidential figures to be unredacted. Staff would refile its buck sheet. As far as the calculation of the penalty, whether figures are confidential or not doesn't impact the mathematics of how the penalty is calculated.
No, but the concern that when you and I had our initial dialogue, the concern was that if you were to make public the initial, the sort of the numbers, not the revenue numbers, but the other numbers, that you could reverse engineer and find out what the revenue numbers were. If we in our order do not see the reasons for having the revenue numbers be confidential, then it seems to me that we're also saying that when you're submitting your application for a license, that when those numbers, the revenue numbers are put in, there's not a confidential form that's being submitted in a public form. It would just all be public.
So, if it becomes required that and the way it's done now is that and as I've alluded to previously, the majority of companies that put their revenues in the application do so confidentially. So there's a option in the e-filing system to upload an attachment as confidential, and there's also a public option. And typically, what it means is that the confidential figures simply aren't included in the public attachment.
No, I understand what you're saying. That's the existing process. But you were concerned that if we made all of the formula public, that could be used to reverse engineer, and the confidential piece can be discovered. But if our decision now is to make everything transparent, because we don't see the point of confidentiality on this because there's no real basis for it, then what are we doing in terms of the filing, the initial filing with the revenue numbers there? Are we going to continue to have them be confidential, even though we're making if we make a ruling today that none of it needs to be confidential? I mean, I guess we need to take it under advisement about how far we go, because personally, I don't think we should be issuing a license today anyway, because the company says they have materials that they never provided to staff. So that needs to happen regardless of what we do. But I guess maybe we need to take the rest of it under advisement too. But I'm also trying to figure out what the consequences of what we're doing, what we could be doing today, would have in terms of the filing itself. Would there be a confidential piece of it if we're finding that none of the information should be confidential?
Right. So, yeah, Commissioner. If the commission required today that this information just be public, then going forward it would only be public. Although I'm not sure how that would affect applications from the past, if the formula could reverse engineer that before the requirement was passed by the commission. That's something I'm not currently sure about, what that impact would be.
Thank you.
Okay, any other questions? All right, so here's what I think we're going to do. We are going to hold this in abeyance pending two things. One, I want a detailed explanation about your operations when you didn't have a license. You know, as you've sort of alluded to, well, we mainly dealt with commercial customers, not residentials, and we were serving as a broker. But I guess I want on the record, you know, a complete explanation about what it is you were doing in this state when you didn't have a license, and any explanation you want to provide about why you didn't think you needed a license. Now, if you've already given this to staff, since staff said that you told them about your non-licensed situation, then just forward that information. But if there's more to answer my specific question, then provide that. Secondly, in line with Commissioner Sushman's earlier request, I want the company to submit the marketing materials and other commercial and customer relations information that you're going to be using should you get a license. And then after we review all that, we'll issue an order regarding both the granting of the license and the amount of the fine. So, and with Commissioner Sushman.
Aye.
Commissioner Parve. Aye. Commissioner Richard.
Aye.
Commissioner O'Donnell. I vote aye.
The next item on today's administrative agenda is item number 11, Wakefield Solar Energy Center, LLC. Its request for regulatory relief from Community Solar Pilot Program operational deadline for Wakefield Solar Energy Center, LLC solar project in Carroll County.
Good morning, Chair, Commissioners. Michael Dean on behalf of staff. Item 11 is a filing by Wakefield Solar Energy Center, LLC, requesting that the Commission extend the operational deadline for its community solar project, which was approved under the Community Solar Pilot Project Program by 6 months. A community solar generating system is a solar energy project that does not exceed 5 megawatts and provides electricity or credits the bills of its subscribers, with at least 40% of whom are low or moderate income persons. Commission regulations at Comar 20.62.03.04C provide that when a approved project fails to commence operation within 36 months of its application, the electric company is to remove that project from its pilot program queue. The regulations at Comar 20.62.10.04 also provide that a regulation may be waived for good cause shown. The filing states that the project, which is located on a 8.69 acre field near New Windsor, has experienced unforeseen delays in its permitting process in Carroll County, and requests that the operational deadline be extended by 6 months from March 17, 2024 to September 17, 2024. Attachment A of the filing details the record of its local permitting process. The filing states that the company has procured all the major equipment for the facility and contracts necessary for its construction. Staff has reviewed the filing and finds that good cause exists for the waiver of the operational deadline regulation. Staff recommends that the Commission grant the waiver requested by the company and extend the operational deadline for the Wakefield Solar Energy Center's Community Solar Pilot Program project from March 17, 2024 to September 17, 2024.
So, any questions for staff?
Good morning, Mr. Chairman and Commissioners. Max Cook on behalf of Wakefield Solar Energy Center, LLC. I also have with me Mr. Joe DeMarzo Sanchez from the project company. We've reviewed staff's filing. We have nothing further to add. We're here to answer any questions from the Commission. Thank you.
Mr. Chairman?
Go ahead, Commissioner Barbe.
Thank you. I just wonder if you could give us some insight as to the nature of the delay at the county level and how long that delay in permitting went.
Thank you, Commissioner. I can take a stab at it. So the main issue here and why we're before the Commission is the project had received all of its initial permitting, secured all of its equipment. It made a slight design change to go from a tracking system to a fixed tilt system, resulting in a smaller footprint. When the project brought that to the county required the project to go back to 8 different agencies whom already had granted approval to review the less invasive plans for the project. So as a result of that, it's gone through 8 re-reviews from these agencies. Since that time, Commissioner, the project has received all of those approvals and it's now finalizing its building permit. But that's the background, Commissioner.
So you made the project smaller and had to go through all the 8 hoops again.
That's correct, Commissioner.
And how long did that take?
8 to 9 months, Commissioner.
Aha. Okay, thank you very much.
Any other questions? So just so I'm clear on this, this was not a situation where the county government was sort of slow walking the process. This was mainly because you guys made this change in it and it was just sort of regular operations, correct?
That's correct.
Okay. So with that, I move we grant the company the requested waiver and extend the operational deadline for Wakefield Solar Energy Center's community solar project from March 17th, 2024 to September 17th, 2024. Commissioner Sussman?
Aye.
Commissioner Barbe?
Aye.
Commissioner Richard?
Aye.
I vote aye.
Thank you, Mr. Chair. The next item on the administrative agenda is item number 12, Solar Landscape. Filed its request to qualify Queen Esther Apartments LLC as a low to moderate income subscriber under Maryland's Community Solar Program.
Good morning, Chair and Commissioners. Harrison Scher, accompanied by Drew McAuliffe. On behalf of staff, on December 8th, 2023, Solar Landscape filed a request to qualify Queen Esther Apartments as a low-income subscriber in Maryland's Community Solar Program. Queen Esther Apartments is a 321-unit affordable housing complex located in Baltimore. It will use approximately 850,000 kilowatt hours annually of program capacity within BGE territory. Queen Esther Apartments is in HUD's Housing Choice Voucher Program, commonly referred to as Section 8 housing. The company has filed a copy of the Section 8 housing contract, which covers 288 units. According to Commission's letter order dated February 14, 2020, self-attestation plus proof of participation in a qualified federal program is sufficient to verify low-income status. Staff recommends that Solar Landscape's request be approved and Queen Esther Apartments be qualified as an LMI subscriber in Maryland's Community Solar Program, and I am available for questions.
Any questions?
Yeah, Chairman Commissioners, Eric Wallace on behalf of Solar Landscape, and I appreciate staff's comments. We had a couple discussions about this as was in the works, and there was one clarification I wanted to add in our request for, to the extent the Commission is inclined to move to grant this request. The regulation that we cited on page 2 of our filing says that the Commission can, an operator of a low-income multifamily dwelling unit may apply to the Commission to qualify as a low-income subscriber for the purposes of the pilot program. So the clarification that we're requesting is not just that the Queen Esther Apartments be certified as LMI, but as the low-income subcategory of LMI. And that's important because Solar Landscape has a number of low-income LMI projects, 10% of which have to be specifically subscribed by low-income subscribers. And so Solar Landscape has a portfolio that includes a number of rooftop projects. It's some great projects that they're working on. We want to make sure that we're able to get the targets hit for low income to be able to turn those projects on and serve not just the low income segment, but the full LMI segment of those projects and all the other subscribers. So we just ask that the Commission make that clarification and happy to answer any questions.
Any view on that?
I have no issue with them being qualified as low income. They've been approved for Section 8 housing, which has stringent financial qualifications, so I believe they would qualify as low income.
All right. With that, I move we approve Solar Landscape LLC's request to qualify the Queen Esther Apartments LLC as a low or moderate income subscriber in Maryland's community solar pilot project.
And specifically low income, not just low or. That was
So-
that was the piece that was important.
Just so I'm clear on this, if the motion says just low, that's actually what you want?
Yeah, that's a subcategory of lower moderate. So that the challenge that we have is if we're certified as LMI, that covers both categories, and it's unclear about whether that is sufficient to satisfy the 10% low income piece.
Okay, all right. So with that, I move that we approve the company, Solar Landscape LLC's request to qualify the Queen Esther Apartments LLC as a low-income subscriber in Maryland's community solar pilot project. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, the next item on today's agenda is item 13, Arcadia Power, Inc. Its request for approval to qualify Riverfront as low to moderate income subscribers under Maryland's Community Solar Program.
Harrison Chair, once again on behalf of staff. On November 20th, Arcadia filed a request to qualify Riverfront as a low-income subscriber in Maryland's Community Solar Program. Riverfront is a 126-unit building located in Baltimore. It will use approximately 30,820 kilowatt hours annually of program capacity within BGE's territory. Riverfront maintains a low-income housing tax credit contract issued by the Department of Housing and Community Development on December 1st, 2017. The company has filed a copy of the contract as support. Once again, according to the Commission's letter order dated February 14, 2020, self-attestation plus proof of participation in the qualified program is sufficient to verify low-income status. Also, the Commission recently approved Red Ball Energy Co., LLC as LML subscribers, who also use this low-income housing tax credit as justification. This was on September 20th, 2023. Accordingly, staff recommends that Arcadia's request be approved and Riverfront be qualified as an LMI subscriber in Maryland's Community Solar Pilot Program.
So I take it there's nobody here from Arcadia, right?
Doesn't appear to be. I did reach out to the
No, that's fine.
applicant.
So, okay, with that, I move that we approve the company's request to qualify Riverfront as a low or moderate income subscriber under Maryland's Community Solar Pilot Program. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 14 is Arcadia Power, Inc. Its request for approval to qualify Hampstead Village LLC as low to moderate income subscribers under Maryland's Community Solar Program.
Harrison Chair on behalf of staff once again. On November 20th, 2023, Arcadia filed a request to qualify Hampstead Village as an LMI subscriber in Maryland's Community Solar Pilot Program. Hampstead Village is a senior community located in Hampstead and will use approximately 327,144 kilowatt hours annually of program capacity within BGE's territory. Hampstead Village maintains a low-income housing tax credit contract, and it was issued by the Department of Housing and Community Development on June 21st, 2004. The company has again filed a copy of the contract as support. Once again, the Commission has previously approved this low-income housing tax credit as justification as seen in the Red Ball case, which was from September 20th, 2023. Accordingly, staff recommends that Arcadia's request be approved and Hampstead Village be qualified as an LMI subscriber in Maryland's Community Solar Pilot Program.
Okay, with that, I move we approve Arcadia Power's request to qualify the Hampstead Village LLC as a low or moderate income subscriber under Maryland's Community Solar Pilot Program. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 15 is from Arcadia Power, Inc. Its request for approval to qualify Broadway 2 LP as low to moderate income subscribers under Maryland's Community Solar Program.
All right. Two to go. Harrison Scherer again on behalf of staff. On November 20th, Arcadia filed a request to qualify Broadway 2 as low-income subscriber in Maryland's Community Solar Pilot Program. Broadway 2 is a 132-unit building located in Baltimore. It will use approximately 350,744 kilowatt hours annually of program capacity within BG's territory. Broadway 2 maintains a low-income housing tax credit contract issued by the Department of Housing and Community Development since June 20th, 2002, which the company has filed a copy of the contract as support. The commission letter order dated February 14th, 2020 says that self-attestation plus proof of participation is sufficient to verify low-income status, along with the Red Ball case, which previously used the low-income housing tax credit as justification on September 20th. Staff recommends that Arcadia's request be approved and Broadway 2 be qualified as an LMI subscriber in Maryland's Community Solar Pilot Program.
So with that, I move that we approve Arcadia Power's request to qualify Broadway 2 as a lower moderate income subscriber under Maryland's Community Solar Pilot Program. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item 16 is from Arcadia Power, Inc. Its request to qualify Bell Park Tower as a low to moderate income subscriber under Maryland's Community Solar Program.
Harrison Scherer on behalf of staff. On November 21st, Arcadia filed a request to qualify Bell Park Tower as an LMI subscriber in Maryland's Community Solar Pilot Program. Bell Park Tower is a 235-unit affordable housing complex located in Baltimore. It will use approximately 1.2 million kilowatt hours annually of program capacity within BG territory. Bell Park Tower participates in HUD's Housing Choice Voucher Program, commonly referred to as Section 8 housing. And the company has also filed a copy of the Section 8 housing contract. Commission's letter order dated February 14, 2020. Self-attestation plus proof of participation in a qualified federal program is sufficient to verify low-income status. Accordingly, staff recommends that Arcadia's request be approved and Bell Park Tower be qualified as an LMI subscriber in Maryland's Community Solar Pilot Program.
I move that we approve Arcadia Power's request to qualify Bell Park Tower as a lower moderate income subscriber under Maryland's Community Solar Pilot Program. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item 17 is from Arcadia Power, Inc. Its request for approval to qualify HSP2 LLC as low to moderate income subscribers under Maryland's Community Solar Program.
Thank you. Harrison Scherer again on behalf of staff. HSP2, once again, also is using the low-income housing tax credit as justification for support to qualify as a LMI subscriber within Maryland's Community Solar Pilot Program. And once again, that precedent has been set by the Red Ball Energy Co. LLC, who used that low-income housing tax credit as justification for since September 20th, 2023. Accordingly, staff will recommend that Arcadia's request be approved and that HSP2 be qualified as an LMI subscriber in Maryland's Community Solar Pilot Program.
So I move that we approve Arcadia Power's request to qualify HSP2 Hillside Park LLC as a lower moderate income subscriber under Maryland's Community Solar Pilot Program. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. And with that, we conclude the administrative